Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
All caps means you're either panicking or trying to represent yourself in court. Both are mistakes. Your feelings are adorable, but they're not admissible, persuasive, or even interesting without evidence. Yes, Heather hates immunity doctrines. It's a personality trait at this point. You don't need to remind her, she wakes up angry about it. Bring receipts. "No, I heard it from so and so." This is quid pro quo, not next door. Screenshots are statutes only. Don't fight each other. Fight the law. It deserves it more. If you're offended, excellent. That means you're awake, paying attention, and probably new here. No diagnosing the host. She's petty, not pathological. And don't diagnose anyone else. Stay in your lane, please and thank you. Do not summon the mods. They're tired, hangry, and may bite when provoked. Disagree loudly if you must. The algorithm eats drama for breakfast. Just keep it cute while you argue wrongfully. If you're taking screenshots of my chat, touch grass, tell your handlers. I said hi, and find a hobby that isn't me.
Hey everybody, welcome back. Happy Monday. Oh, do we have an interesting one today? So, apparently, since everybody's aware by now. Everybody's aware. And if you've been living under a rock, Leslie Lips, bad lip injections, Federigos, accused a bunch of people, including me, of a felony, which is defamation, accusing someone of a crime for reading publicly available documents. So in my petty revenge, I can't sue you because you have 2 houses in foreclosure and I will get nothing but a waste of time and a migraine. Have decided that every Monday we are going to put her dirty laundry out on the internet, because when you trauma dump in legal filings, don't be upset when people get upset or read your dirty laundry. So, quick rundown of tonight. Oh my god. Today's theme is community litigation because apparently there's open enrollment on this lawsuit like it's fucking Medicare. First, the court has politely asked, "You're retired? Why does this case matter?" It's not shade, it's jurisdiction. Oh. Mm. And I'm not going to give you spoilers because, but this isn't Lips versus the Bar. This isn't Lips versus the World. This is everybody puts their 2 cents in. It's maybe where she got the idea of sticking her nose where it doesn't belong. And we'll get into that. Hope everybody is doing well. Oh, this one might give you a slight of a... It's going to be an awesome show, I can tell already. Hope everybody is doing well today. So we're just going to get straight into this because, oy. But there's another lawyer that sticks their nose into this situation. And we have an article on him because he stuck his nose where it didn't belong. But first, we are going to get started with the show cause order. Because everybody loves a good show cause order, right? This is where the bar is just like, why are we here? Sticking your nose where it doesn't belong is the best way to get it bent out of shape. I know, right? Speaking of sticking your nose where it doesn't belong, my nose is actually healed now. The bruise is gone. It no longer hurts to inhale. Yeah, for those of you who know the story, you know. For those of you who don't know the story, I'm not repeating it again. But my face is healed. There was a little bit of an incident on Friday, which is why I didn't stream on Friday. Cheers, my face doesn't hurt anymore. All right. So, as always, we're not reading these word for word because God, Lord help us. So at the time that she filed this complaint, Ms. Frederigo's was an attorney admitted to practice law in Florida. And in the second amended complaint, she asserted several challenges related to disciplinary proceedings against her by the Florida Bar. Since the filing of the second amended complaint, Ms. Frederigo's has permanently retired from the practice of law in Florida. The disciplinary proceedings against her have been dismissed as a result. There's that caveat that she used to claim defamation because she retired, so the disciplinary proceedings were dropped. It's a loophole. It's a loophole. Therefore, it appears that claims raised in Ms. Frederigo's second amended complaint are moot. Judges love that word. Based on the foregoing, it's ordered that Ms. Frederigo's show cause in writing on why this matter should not be dismissed for a lack of subject matter jurisdiction. Hate that freaking phrase. Every time I hear subject matter jurisdiction, it makes me think Daryl Brooks. And for those of you who know me, Daryl Brooks makes me want to put a hole in the wall. Because I hate him with a passion. I hate him more than anybody else on this fucking planet. For reasons, because Waukesha is my hometown. I actually got my first tattoo, the one that says "Beautiful Disaster." That's why the "Beautiful Disaster" thing is in my intro video. I got my the tattoo shop that I got my tattoo from, my first tattoo ever, is actually either on the parade route or like a block away. So I hate anything subject matter jurisdiction that reminds me of Daryl Brooks. I want to punch a hole in a wall. By its very nature, a moot suit cannot present an Article III case or controversy by federal courts' lack of subject matter jurisdiction to entertain it. I would love to have some. I would love to have 10 minutes with Daryl Brooks. 10 minutes and a hammer. Just saying. Think Italian mafia. You can do the math. Clerk of court is directed to send a copy of this order to Miss Federico's. Done and ordered. So she had a show cause order as to why this case should actually not be dismissed, because there's no there's no reason to keep it going. Hence, however, before she could entertain the show cause order, this dude, oh boy, oh I'm thinking 200 yards and 200 rounds, 7.62. Just saying. No, I'm thinking a hammer and some fingers. And maybe a pocket knife. Not like I've thought about this or anything. Just saying. Oh, yeah, the judge couldn't even stand him. Well, Mama Squid actually wanted to be a dancing granny when she retired. And so the fact that he injured and killed some of the dancing grannies kind of makes it just a tad bit personal. So this is Erwin Rosenberg's motion for permissive intervention. We're going to skip all the case law about why he wants this and get to his section of who he is. Because he just mentions a bunch of case law. 11th Amendment does not prohibit Rosenberg's claim against the Florida Bar and Supreme Court of Florida. Well, we're going to skip down to all that matters, because we don't care about the Rooker-Feldman doctrine. I really don't give a crap. I care about embarrassing lips and maybe showing the world where she got her lovely ability to stick her nose where it doesn't belong. Oh yes. That right there. Erwin Rosenberg's proposed intervener complaint. This court has jurisdiction as the claims present a federal question. August 6, 2012, Hunter Honefeld, acting on behalf of the Florida Bar, an agency described as an arm of the Supreme Court of Florida with the responsibility to enforce Chapter 4 of the rules regulating the Florida Bar, known as the Rules of Professional Conduct, emailed Rosenberg with a subject line, Florida Bar grievance brought by Gabala against Erwin Rosenberg, a lawyer with a ethical track record. But wait, we'll get into it. Lips never knew the plot. She's not even in the same damn book. Let's be honest. Is it an embarrassing her, though? Oh, yeah, that's right. You have to have, like, a conscience and all of that shit to be embarrassed. True. However, I will take whatever slight dignity she has left. But Erwin Rosenberg has introduced himself. Dear Mr. Rosenberg, I've been assigned to investigate this complaint. With respect to your response, I need additional materials to further my investigation. First, need a copy of the briefs in the appeal to the 4th District Court of Appeals that you took from the sanctions order. Second, I need a copy of the docket sheet from the underlying litigation to determine the status of the post-order motions you filed in the trial court in light of the affirmance of the order on appeal. Sweet Jesus. Finally, I need a supplement to your prior response explaining whether you are taking the position that your post-order motions impact the current validity of the decision on appeal affirming the sanctions order. If that's your position, please cite all relevant authorities supporting that position. And then he gives his deadline and, thank you for your anticipated cooperation. Uh, so he goes to cite more case law, but that investigation constituted an infringement of Erwin Rosenberg's right under to participate in an area of trade free from interference by the states and free of monopolies. Sweet Jesus. When you think this shit can't get more ridiculous, she was ridiculous long before she ever stuck her nose into any of Jeremy's affairs. The same is true with regard to any of the Florida bar's investigations pursuant to the enforcement of the bar rules. The Florida bar's filed case where the Supreme Court of Florida ordered suspension of Rosenberg's license to practice law in Florida. Rosenberg had filed in the U.S. District Court of Florida a case against the state of Florida, the Supreme Court of Florida, the Florida bar. Oh my God. So Wikipedia, this is has nothing to do with really to do with Hales, except for the fact that this is an offshoot. The fact that she called me a document felon, basically called me a felon for reading publicly available court documents. So we are deep diving into her history of every document she's ever filed and exposing her dirty laundry for all the world to see, because she trauma dumps in legal filings and I like exposing it. So it's a sidebar, because in covering the Hales stuff, she decided to stick her nose into and basically defame me for call me a felon for reading publicly available documents. So we're doing a deep dive into her history. So this is all about I'm not suing her for defamation because she has nothing. She's got 2 houses in foreclosure. Like, she's got nothing. So I am deep diving into her history. So it's kind of an offshoot of yeah. And it's kind of to I would say embarrass her, but somebody brought up the fact that you have to have like conscience and shit to be embarrassed. So I call her Lips because she did. If she wouldn't have called herself Lips, that's the only reason why I do. So, but I can definitely agree with you. I generally won't call people nicknames. Like I still call Lynette and John, but she called herself Lips, which, if you call yourself a nickname, uh, I don't know. I don't know. It's an offshoot of an offshoot. Yeah, but we're kind of investigating the name, like, I'm fine in doing this, because I had covered her in the past, but then, like, I had no reason to cover her because it wasn't vital to my day. However, I am finding things in here that are making her behavior now. I'm I'm figuring out where she got it from, but I'm seeing things that make a little bit more sense that I'm realizing have maybe nothing to do with Jeremy and are just her personality, where I thought it was like maybe a Jeremy thing, because I don't know why, but Jeremy has a way of attracting the crazy people. I don't know. He has a way of bringing the crazies out of the think Just J Hip started the Lips name. When she refers to herself as Lips, that's where it's like, okay. The only 2 people that I really like call nicknames, and I will not apologize for it, is Bruce Matskin and Lisa the Thunder Cunt, whatever her last name is, because they went after my kid. They laughed at the possibility of my toddler choking. So, you know, but other than that, like, so nice of you to use that Navy training to use. You want documentation? Well, here it is. We can get it in triplet or in a 5-part form. Yeah. Um, that's wackadoos out of the woodwork. Perfect thing. Perfect way. So it's just just an interesting, like, but I'm seeing for Annie, thank you. Thank you for the $5 super chat here for the pettyverse. Yeah, Viggy, I don't know how long you've been around my channel, but I got into this case because I went on someone's channel and we weren't talking about it, and they had asked me one question, and all I said was I was worried about the child. That I didn't say anybody was a bad mom. I didn't say nothing about nothing. All I said was I'm worried about the child, because as a mom, worried about the child. And that gave Bruce Matskin license to talk about my child choking on an Apple Pencil. So, you talk about my child, and then that's one of the things that I will never, but I had 2 streams on Lips of back in the day, and I had mentioned these cases, but I hadn't really gone a deep dive. But when you out of nowhere decide to call me a felon, because I did a stream talking about the paperwork she filed with the FBI and with the Australian government on DJ Radis, because they ended up in my inbox. So I decided to talk about them. And then she called me a felon for reading publicly available documents. That's when I'm like, oh, you want to play? Let's play. Let's play. Yeah. Good morning, Squid. Just got here, so catching up. Oh, Tammy, I don't know if you caught last night's stream on the other channel, but you might enjoy that one. We had a lot of fun on the other channel last night. Sort of fun, if you can talk about it. We did a stream talking about the do's and don'ts of rib fractures. So using my actual knowledge. So this is interesting because this is where she sued the Florida bar. But somebody else interjected themselves into her court case. As far as I know, this Erwin Rosenberg is from Miami. She doesn't know this person. I couldn't find a link to her. Yeah, you stayed completely out of it until they commented on Baby Squid. Yeah, I'm not gonna lie, my petty side took over, and I'm like, you are trying to intimidate me into not talking about it. Now I'm gonna talk about it. And Lips kind of did it again. She felt like she was trying to intimidate me into not talking about something, and I'm like, you just opened a can of worms, because, she picked the wrong sandbox to go scratch in it. But I'm wondering if this is part of where she learned or got the idea to stick her nose into someplace where it doesn't belong, because this guy did it to her case. I'm just curious. So what you're seeing is that there's a high percentage of wackadoodle lawyers in Florida. Florida lawyer like Florida man. I'm not going to speak on all Florida lawyers, because I did recently speak to a Florida lawyer that is helping me with a certain situation not related to any of this. It's helping with a 3D life just situation with, like, a business issue. It's interesting that not all Florida lawyers are like this, but they seem to be the loudest. because I do have a I do have an article on this person specifically. So he's talking about Florida bar case where the Supreme Court of Florida ordered a disbarment. So he was actually disbarred by the Florida bar. On May 3rd, 2016, the court in Erwin Rosenberg v. State of Florida, Supreme Court of Florida, and the Florida bar dismissed Rosenberg's claim as non-justiciable because the plaintiff had been disbarred on separate grounds. Any order from this court enjoining his suspension from the practice of law would be moot. January 30th, 2017, the District Court of Southern Florida issued an administrative order, a reciprocal suspension against Rosenberg. Like, on April 5th, 2017, Rosenberg filed a Miami-Dade County case, small claims division against that person, not important, in his official capacity as Chief Justice of the Supreme Court of Florida, as to the Florida suspension and disbarment. The suit was also against Kevin Michael Moore in his official capacity as Chief Judge of the U.S. District Court for the Southern District of Florida, as to a federal court June 29th, 2015 suspension. Sweet Jesus. And Vicky, I can totally understand if you think I'm being biased in this particular case. When it comes to lips, totally and completely, I'm not even gonna even attempt to act like I'm not being I'm being non-biased. I will take that one. Love me or hate me for it. I will take it, whatever your opinion is. I just don't take kindly to being called a felon and basically being defamed. And this is my payback to her personally. So this is not even close to being biased or non-biased, but I will take that as I will fully admit that, and I'm not even trying to be non-biased in this particular situation with this particular person. Everybody else, I still try to see both sides, but when you call me a felon for doing nothing other than reading publicly available documents, I'm never going to be non-biased when it comes to her situation ever again. Ever again. She kind of burnt that bridge. So, like, I will take that one. Feel free to disagree with me, and I appreciate it either way. It's just, you know, I can't really sue for defamation because she has nothing, and it would be a waste of time and energy. So I might as well get some entertainment value from it. That's my only plus when you accuse someone of you don't even have to be a Jeremy fan, but when you accuse someone of a crime such as what she accused him of at a storage unit, I have a problem with that, a big problem with that. So that's just me. You know, I have a huge problem of accusations without proof, especially when it comes to smexy time crimes. So, and hey, Kasha, thanks for being a member for 10 months. Hey, Squid. Hey, you. So, side note, I told Kasha and her husband to stop sending me puppy videos or black lab videos. So now they send me other puppy videos. So, and hello, late to the party. It's an interesting situation today because this stream just isn't about lips. There's a new player in the game who's been disbarred by the Florida bar. Yeah, FAFO is what I say about lips. Yeah. And I think when I was talking about her last year and I did those 2 streams last May and June, I did call her Leslie. I didn't call her Lips. However, she that ship done sailed and sank like the damn Titanic. All right, the Florida bar filed a case where on September 25th, 2015, the Supreme Court ordered a permanent disbarment. Yeah, false accusations are the bottom of the cesspool. Yeah. Dashing in late, but this just isn't just you having a problem with unfounded accusations. This just gets more and more ludicrous. Yeah. So this is Erwin Rosenberg, who filed a motion to intervene in Lips's case against the Florida bar, which I find very interesting because this is the first time that I'm finding where someone else intervened in her case. And maybe it's where she got the idea that intervening or sticking your nose into other people's business is an okay practice. I don't know. I don't know. No, they're trying to get us they're trying to get me to convince Mr. Squid to adopt a puppy for the little. So they send puppy videos all the time. Um, on May 10th, 2018, Judge Middlebrooks entered an order in that case, granting in part Rosenberg's motion to amend the prior dismissal, ruling that dismissal against Chief Judge Labargo is without prejudice, as the dismissal is based on the Rooker-Feldman and the 11th Amendment. Huh. All right. So basically, he has filed a motion to put himself into this case. We are going to read a so here's his actions. The suspended with conditions 5/28/15 or 2015. Disbarment 4/15/2016, and then permanent disbarment 9/25/2017. Oh, we're getting to that. I did a little research, and there are numerous articles on him, so I pulled one just to give us kind of a background. But he's got his own claims. Count 1, pursuant to Constitution's Commerce Clause against the Florida Bar for declaratory judgment, Chapter 3, rules regulating the Florida Bar, the rules of discipline, are unconstitutional. Of course. Claim pursuant to the Constitution's Commerce Clause against the Supreme Court of Florida for declaratory judgment, Chapter 3, are facially unconstitutional, and for an injunction prohibiting its enforcement. And this is all on behalf of Lips. Why he put this in Lips's case, I don't know. So he's like, Deuce. Yeah. But so we will get to his background a little bit, and this was filed October 10th of 2025. So he is still filing stuff. Remember, he's from Miami. Okay? Miami. Remember that. It's important to the first sentence of this. Federal judge dismisses majority of lawsuit by disbarred attorney Erwin Rosenberg, affirming state jurisdictions in reciprocal discipline cases. A federal judge in Manhattan. What is it with Florida and New York? Kind of doing a reciprocal thing here with somebody else. Has dismissed the majority of a due process lawsuit filed by former attorney Erwin Rosenberg, who contested his disbarment in Florida and the subsequent reciprocal disciplinary actions in Massachusetts and New York. The court determined that it lacked personal jurisdiction over disciplinary officials from other states. Rosenberg's legal troubles began in Florida, where he was permanently disbarred by the Florida Supreme Court for practicing law in contemptuous defiance of court orders. Despite the disbarment, he continued to represent clients and hold himself out as an attorney in good standing, leading to further contempt proceedings and his eventual permanent disbarment. And this article does have docs from Justia. Following his disbarment in Florida, Rosenberg faced reciprocal disciplinary actions in other jurisdictions where he was licensed to practice. In Massachusetts, he failed to notify the Board of Overseers of his Florida disbarment until January of 2021, violating a state bar rule. Consequently, the Massachusetts Supreme Judicial Court disbarred him in December 2021, a decision affirmed on appeal in February 2023. I mean, dude, when do you just don't know when to stop? Similarly, in New York, the Attorney Grievance Committee for the 3rd Judicial Department sought reciprocal discipline. Rosenberg opposed the motion, but in February of 2022, the 3rd Judicial Department disbarred him, citing his misconduct in Florida. His subsequent motions for reconsideration and to vacate the disbarment were denied, with the court finding no substantial constitutional question involved. In his federal lawsuit, Rosenberg alleged that the disciplinary proceedings in Florida, Massachusetts, and New York violated his procedural due process rights under 42 U.S. Code 1983. He contended that the rules of professional responsibility imposed content-based restrictions on speech, infringing on his First Amendment rights. Oh, that First Amendment. However, both Massachusetts Supreme Judicial Court and the New York Appellate Division have previously rejected this argument, affirming that states may regulate professional conduct, even when it incidentally involves speech. The federal court's dismissal underscores the challenges attorneys face when contesting reciprocal disciplinary actions across multiple jurisdictions. It also highlights the judiciary's deference to state bar authorities in regulating the legal profession and enforcing ethical standards. We have found Bruce's brother. Well, we have found like Bruce's brother from another mother. I mean, does this not sound like Bruce? I'm just saying, like, that sounds a lot like Bruce. And I will put this article in the Discord. Because the things you find, and I would have never found this little interesting piece of information, had lips, not opened her big mouth. No pun intended. I mean, y'all, if she had never ran her mouth and started talking shit when she didn't need to, her and her chat could have kept my names out of their damn mouth. Did they all come from the same jacked up gene pond? You know, I'm starting to think there's some shit there. I'm starting to think there's some like Alabama inbreeding going on. No offense to my Alabama fans and friends. However, I'll try not to. I will try not to. I can't guarantee it. I can't guarantee it. I will do my best. And this is her getting back to her documents and craziness. This is answering compliance with order to show cause. Did they all go to the same law school? I think they got their law degree in a Cracker Jack box. And drive safe. And Hazel Montiango, thank you for the 10 pounds towards Pacer fees. Thank you. I'm not looking forward to what that Pacer bill looks like. And Gasha, thanks for the $2 super chat for the little. I appreciate you guys so much. I'm trying to catch the super chats as I get them so that I don't forget them. Because Ammo's Girl, and thank you, Ammo's Girl, for the $20 the $20 Venmo the other day. I completely forgot about it. I did not see it until later, and I apologize. Like, oh, Lips went to an online law school. Probably. All right. Procedural history. We kind of know this by now. She filed an injunctive relief claiming violations of the Americans with Disabilities Act, Florida Civil Rights Act of 1992, and Florida Statute Annotated 760.01, Federal Declaratory Judgment Act, violations of the 14th and 5th Amendments of the United States Constitution. I mean, see, once again, I get very like I get very picky and nitpicky, especially when I don't like somebody, about grammar. And like, I would write this a little different. Like, fifth, anything under 10 should be written out. So FIFTH. And for me, chronological order, personal preference, law and disorder. And here and after, thanks for the $5 super chat. Pacer funds. I appreciate you guys. And for those of you who do want to support the channel without giving your money to YouTube, I do have a Ko-fi account. YouTube takes 30%. Ko-fi only takes 5%. So Alabama's jacked up dead outlaw reverse cow. Nope. Not reading the rest of that. Maybe they had Professor de Thomas's in law school. God. Jeez. All right. Plaintiff makes specific claims that the Florida Bar disciplinary process is unconstitutional by not affording an accused attorney an impartial tribunal. Of course, we know this. Plaintiff alleges voluminous facts that deprived her of constitutional protections during the disciplinary process, ultimately leading to the plaintiff seeking permanent retirement. Florida Supreme Court approved plaintiff's petition for retirement. Lawyers under a regular retirement may petition for reinstatement of membership. However, plaintiff cannot due to the nature of her permanent retirement. Hey, Captain Kern! Members of the local bar committee in charge of the plaintiff's disciplinary issues gave the plaintiff no choice but to permanently retire or endure the process, the very process that the plaintiff alleges is unconstitutional, and risk fact-finding controlled by this unconstitutional process that could be detrimental to the plaintiff's reputation and future ability to earn a living and to support her family. I'm just thinking maybe she had more problems based on all the lawsuits that she had going on that didn't involve the bar. And also, if you don't think you did anything wrong, why not stay and fight? Why not hide? This has allowed defendants' process to coerce accused attorneys into voluntarily not practicing law, thus allowing large firms to monopolize Florida's legal market. Jesus. So, this court filed a show cause on why plaintiff's case should not be rendered moot, relying on National Advertising Company versus City of Miami. Defendants took no measures to address or amend any unconstitutional provisions within their disciplinary process. Her problems were created in her mind. Yes. Yes. Here listening, waiting for paint to dry, and eating lunch. Wow, such an exciting life. Well, you know. Yeah, I'm not getting into that one. There's certain things that I just will not touch. And I talk about enough child cases on this channel. The case law that she cites is highly distinguishable because the federal court's findings for mootness I didn't know that was a word, is premised on the defendant's actions of amending the unconstitutional provisions of their city ordinance. That National Advertising Company versus City of Miami and all cited cases within this case make findings for mootness based on a party amending unconstitutional provisions. I do. It is in my it's in one of the things that right here. The link is in there. And also that Kofi uses PayPal. So there's that. In the instant case, defendants have made no effort to amend any of the plaintiff's alleged constitutional provisions. Furthermore, the plaintiff has exhausted all measures for remedies within the state court when the plaintiff filed a petition with the Florida Supreme Court to amend their disciplinary provisions to comport with the recommendations of the American Bar Association's McKay report. You can't force a bar association to change the way they do things. Like, you can't. Like, it's just... And the American Bar Association cannot force a state court or a state bar association to do anything. It's a recommendation, but they don't have that kind of power. I'm not a lawyer, and even I know that. Just saying. Like, I'm just... So she didn't retire to be a full-time mom, as she states. Nope. Not according to the documents. And this is one of the reasons that, yes, I'm reading this and reading these out of pettiness and petty revenge because, you know, I live my life in the pettyverse, which some would consider childish, which I'm okay. I will bite that bullet and be called childish for this sake because it is fucking entertaining as hell. However, I am learning a lot about things that she might have said or might not have said, being true or not. And things or behaviors that she has done in other court cases that Jeremy or Randy might be Randy, because Jeremy's not a lawyer, may be able to use to get her labeled a vexatious litigant. Oh, and that Erwin Rosenberg was labeled a vexatious litigant. Yes. So I liked hey, I'm Marsh, how are you? And your picture is so adorable. So adorable. Putting the record straight. We learn a lot of what people say when they put their entire lives in court documents. Their court documents become public record, or I mean their whole lives become public record. So when they say something on a YouTube channel and it's like, well, that's not what you said in a court record a couple years ago. So were you lying then? Or are you lying now? Just saying. It's an interesting question. And the psychology of trauma dumping in a legal filing, I will never understand. Like, I despise my mother-in-law. However, I never could fathom the thought of suing my mother-in-law because I don't like her and we disagree and we've name called. I don't know. Sometimes my mother and I disagree with each other. I can never fathom suing my mother. I'm sure my mom has called me crazy a time or two. And she might have put the B word after that. And you know what? But I can't ever see myself suing my parents because they called me some not nice words. I just As Gen X is fully aware, if you don't want it read aloud, do not put it in writing. There you go. I wouldn't be able to keep a straight face. I can barely keep a straight face now. Huh. All right. Thus, state court has been given all opportunities to amend unconstitutional provisions within their attorney disciplinary process, leaving the federal court as the only appropriate court able to address these issues of constitutionality. If the Florida Supreme Court had amended unconstitutional portions of their disciplinary process or enacted superseding provisions that addressed unconstitutionality of their disciplinary process, that case would be appropriate case law to rely on in this court order to show cause for the instant case. And in that footnote, she literally just cites a bunch of case law, holding that a Commerce Clause-based challenge to Florida's banking statutes were rendered moot by amendments to the law, Massachusetts v. Oaks, holding that an overbreath challenge to a child corn law was rendered moot by amendment to the statute, Princeton v. Schmidt, holding that the challenge to a university regulation was moot because the regulation had been substantially amended. Okay, so if I were to play devil's advocate for 30 seconds, because Lord knows. All right. I'm sure there are thousands and thousands of lawyers every year who have bar complaints filed against them, whether they be actual complaints or like we saw a few years ago, quite a few, well, 3 or 4 years ago from Kiwi Farms and Nick Rekieta, how they swarmed the Minnesota bar with bar complaints because they hated him. If their disciplinary proceedings were truly unconstitutional, why is it very rare to see a lawyer file a complaint against the Florida bar, citing that Rule 3 is unconstitutional or Chapter 3 is unconstitutional? You would think if Chapter 3 of the rules regulating the Florida bar were unconstitutional, every lawyer who's subject to those disciplinary proceedings would be filing a motion or a lawsuit that they are unconstitutional. But to my knowledge, there's only been a handful. Is it because she's full of crap? And Kirby, thanks for the 10 gifted Squid Pro Quo memberships. Thank you for keeping the chat green. I appreciate you so very, very much. It means a lot to me. Oh, there we go. Oh, yes. My mom called me several names. When we got older, it became a good laugh. Now that it's all good memories and we got laughs out of it. Yeah, like it, you know. And Kirby, you have no idea how much I appreciate you. Like, and hey, Malin, and no, I'm not. I love you, but you can rewind and play at 2 times speed. And hey, Mary, how are you? All right. Oh my goodness. The plaintiff's case falls under an exception to a case and controversy limitation on federal court's jurisdiction. Doesn't this strike me as a pick me girl? Pick me, me. Pick me. Oh my God. And that other guy who filed a motion in this case, who's not even a party in this case, is like, pick me louder. Pick me, but louder. Like, I'm just like, why do people want this much damn attention from judges? Because I really don't. Like, yeah, me, it's all about me person. Yeah, it's just I don't get it. Ugh. Not saying she's full of crap, but Roto-Rooter called to confirm her appointment. I mean, you know, Federal court lacks jurisdiction to hear and decide cases where changes in the law have rendered a case moot. However, it does not render a case moot where no changes in the law have been made. Oh my goodness. It's not the changes in the law, you dipshit. It's the changes in the case. You're bringing this case because there's disciplinary proceedings against you. Now there's no disciplinary proceedings against you because there's no you aren't a lawyer anymore. So there's no disciplinary proceedings, which means why are you bringing this case? Why are we here? Like, it's not. Oh my goodness. Yeah. It sounds like a bunch of fucking whining. Yeah. It's it's like dumb analogy, but it's like the little coming to me to fix one of her toys that we gave away a week ago. It's not yours anymore. I'm not fixing it. It doesn't belong to us. Like it like Squid probably calls me a few choice names from time to time, but I've learned to ignore them. Shut up. Mommy dearest. That's what I call you. Mommy dearest. Because when I was growing up, the phrase in my house was no more wire hangers. If you know, you know. If you are of a certain age and you know what mommy dearest is, my mother did not do all of the mommy dearest stuff. However, she would occasionally go through my closet and pick out any wire hangers and throw them away. And the phrase of the week would be no more wire hangers. I called her mommy dearest. Just saying. Plaintiff, or ultimately leading the plaintiff to retire from the law to avoid an unconstitutional process that still stands today. Thus, the instant case should not be rendered moot despite the plaintiff's status as a retired attorney. Yes. It's the no more wire hangers. Because my mom would go through my closet, I would say once every 2 to 3 months. Because when you get like clothes dry cleaned or you let your friends borrow clothes, you'd put it on a wire hanger so that they didn't take any of the good ones. And my mom would literally go through my closet and take out the wire hangers, and if the clothes were on a wire hanger, she'd throw the clothes on the bed, and I'd have to find a better hanger and put it up. So yes, I called her mommy dearest. And I am 40 years old, and I still call her mommy dearest. It's been a nickname since I was like 10. Ugh. It's been long recognized that the Constitution limits the jurisdiction of federal courts. Is this just me? Okay, is this just me, or is she arguing against herself? It's been long recognized that Constitution limits the jurisdiction of federal courts. They are saying that they don't have subject matter jurisdiction anymore, and you're literally saying, well, yeah, your jurisdiction is limited. The U.S. Constitution, Article 3, provides that judicial power of the U.S. federal courts shall extend only to cases and controversies. Thus, it strictly observed that federal court is limited to cases or controversies. As cited in that same case law from above, a lawsuit is made moot by subsequent developments. Any decision a federal court might render on the merits of the case would constitute an advisory opinion. A change in a law, such as amending a zoning ordinance in that case, or a changing in other circumstances, can give rise to mootness. It has been held that when a subsequent law brings an existing controversy to an end, the case becomes moot and should be treated accordingly. Coalition for the Abolition of Marijuana Prohibition versus Atlanta. Interesting case. In other words, federal courts lack jurisdiction to hear and decide cases where changes in the law have rendered a case moot. She's arguing against herself because then she goes, however, in the instant case, there's been absolutely no actions taken by the defendants to amend any provisions alleged to be unconstitutional by the plaintiff. Yeah, but your whole point was that they were bringing stuff against you, and now they're not. I know this was from 3 years ago, but damn, it's just as, like, annoying to look at and think about now than it is then. No, this is not still going. Um, but and hey, Liz, how are you? Just got errands done, so going back to the beginning. It's been long, it has long been the rule that voluntary cessation of allegedly illegal conduct does not deprive the tribunal of power to hear and determine the case. It does not make the case moot. Secretary of Labor versus Burger King. Quoting U.S. v. W.T. Grant. For a defendant's voluntary cessation to moot any legal questions presented and deprive the court of jurisdiction, it must be absolutely clear that the allegedly wrongful behavior could not reasonably expected to recur. It can't recur. You're not a lawyer anymore. Wouldn't the point become moot if the mootness of the moot point became moot before that moot point was acted upon, or is that moot? Nope. Good thing you aren't a child from the 1960s, or wire hangers would have given you a different opinion. No, that was the 2x4 in the Switch. I'm sure. Well, it's good to see you here. Had to watch the replays. I got goals. Don't we all? Glad you have. Yes, belts too. Don't forget the belts. Don't forget the belts. Oh, and the wooden spoons. I'm sort of kidding, but I'm sort of not. My parents were not evil to me. However, if you acted out of line and they gave you warnings and multiple warnings to get your butt back in line, there were consequences to not getting your butt back in line with repeated verbal warnings. I'm just saying. See Mama Squid swinging a 2x4. Oh, Spawn Trooper with a Dr. Pepper. My parents were not evil to me. However, actions after repeated verbal warnings to correct said behavior were corrected in a different fashion. That right there was cruel and unusual punishment. That was against my amendments. Like that right there. Like that right there was cruel and unusual punishment. Just saying. But it taught you that after the first and the second and maybe the third time of your parents telling you to get your behavior back in a way that it was, socially acceptable, that you would actually listen. Exactly. It's the psychological torture. Psychological torture. You bring one, I think it was Jeff Foxworthy. You bring one too small, they're going to make you go pick out it again. You pick one too big and you're not going to be sitting down for a week. It's just it's just a yes, it teaches consequences. Oh. All right, getting back to this. But I just want to make it clear, Mama and Papa Squid were not evil people and are still not evil people. However, it was made very clear, if multiple warnings were given, that there was not just we're going to keep telling you what to do, is we're going to show you that actions have consequences. I was an awful kid. I was an awful kid who because I just like to argue with my parents. Shocker, right? Um, I wasn't a break the law kind of person. I just didn't know when to shut up when it came to my parents. And I still don't. I haven't learned. It's 40 years and I still haven't learned. Huh. It's just she keeps talking about mootness, and it's like she goes, "Well, in this circumstance, yes, it can be rendered moot. However, in my case, it shouldn't be. It it shouldn't be. It yeah, right there. My mother using my full name. AT1, I don't know about you, but when I got back from boot camp and my mom called me by my first name, I didn't answer. She got mad at me. Was like, "Oh, nobody's called me by my first name in like 3 months." Talked back too much and with an attitude. Nothing's changed. But squid cannot grift. Oh, vey. I still can't. Oh yes, I'm sassy, but I never got in trouble with the law. I just got in trouble with my parents. Yeah, I just had an attitude. Yes, so nothing's changed. Huh. Furthermore, it's certain that defendants will absolutely continue with implementing an unconstitutional disciplinary process if they have made no changes to this process to address the plaintiff's constitutional arguments. So you're gonna fall on the sword for everybody else. How great of you. How amazing. How sweet of her. Sorry, I can't say that with a straight face. How yeah. But isn't it great for our the word won't come out of our of this person to fall on the sword for everybody else and still sue the bar even though she's not a lawyer anymore because she doesn't want other people to go through the same torture that she went through. Oh my goodness. Boat steak. Oh, yep. Don't yeah, the boat steak. It's good when it's first cooked, but then it sits there for 3 hours and becomes beef jerky. So you either get A1 ketchup or uh, p- uh Pete's. You know. In sum, when a court is presented with evidence, substantial likelihood that challenged statute will be reenacted, the litigation is not moot and the court will retain jurisdiction. Coral Springs. Whether the repeal of a law will lead to a finding that the challenge to the law is moot depends on most significantly on whether the court is sufficiently convinced that the repealed law will not be brought back. It is it therefore was held that the case is not moot precisely because of the risk that the city might return to its previous course of conduct, Fort Lauderdale. Thus, the instant case is not moot because the unconstitutional provisions continue to be relied upon to the detriment of those attorneys practicing within the legal profession in the state of Florida. Yes, Texas Pete. Thank you. I was trying to think of maybe I couldn't think of it because I have um like a reaction, not necessarily like a PTSD reaction, but um I have a strong reaction to I have a very very strong reaction to Texas Pete cuz I had it we would do shots. If we were playing cards and you lost, you would have to do shots of Texas Pete because yeah, mental block. Mm. Ah, oh my goodness. All right. So basically, she wants her case to still be on because, God forbid, you know, oof. All right. And then we have um, the Florida Bar's response to the motion to intervene. Um, it's, yeah. Well, did you get your fill of it on WOG Day? I did not have to chug Texas Pete on WOG Day. However, I'm pretty sure I did ingest more salt water than is safe for human consumption. I'm also sure that I'm also pretty sure that um pretty sure that I whatever was on the flight deck for the previous week that didn't get washed, I ingested some of that too. So jet fuel, whatever is on the bottom of people's boots. My Kofi says I don't have anything. So I looked. I don't have anything on my Kofi. So I just checked it. So last time I have anything was February 5th on my Kofi. So I maybe it'll take a second to work. Have a great day. Good to see you. Yeah, and no sorry is needed. Like you are the last person. Well, one, nobody needs to apologize in this chat unless you are directly like insulting my child, and or I give people a warning not to insult not to insult other members of the chat, and they do. However, if your comment is talking about the current person we are talking about, no need to apologize. And hey Moonwolf, how are you? I have not heard anything, but I have also not looked. It's been kind of a crazy weekend. Thanks for everybody who joined Flash Fan and I on Saturday for the recap of week 1 of Georgia versus Edric Faust. That case is nuts. We will be doing that every Saturday for as long as the trial goes on, 4 to 6 weeks. So it's that's a cold case out of Athens, which is where UGA is. It's the cold case in the tragic unaliving, strangulation, pointed or poked with a pointed object, and actual smexy time assault of a University of Georgia law student, where they're trying to introduce some crazy new science, DNA, where her apartment was set on fire after all these things happened to her, and they believed her to still be alive when her apartment was set on fire. So it's a very brutal and tragic, and which is the reason that we need to talk about shit like this and laugh and have fun with things, because on the other end of the spectrum, we talk about awful, horrendous things like that. Yeah. Hey, Carol. How are you? Good to see you. It got delayed until August. So I think August 6th or something like that. I have to look at the calendar. All right. Florida Bar's motion and response. 10 pages. Summary. Court should deny Mr. Rosenberg's motion for permissive intervention for several reasons. First, under the 11th Amendment, the court has no jurisdiction over his claims. Similarly, because plaintiff's claims are due to be dismissed for other grounds set forth in the pending motions to dismiss, the court should exercise its discretion to not permit intervention. Moreover, intervention is inappropriate because Mr. Rosenberg has not asserted a claim that shares a common question of law or fact with the instant case. Doesn't that sound familiar? People intervening in cases where they have no skin in the game, not chicken skins, just skin. Um, it, you put your nose out there and you stick your nose into things where you literally have no business. Plaintiff's complaint. In short, the only thing shared between Mr. Rosenberg's assertions and the plaintiff's complaint is the fact that they disagree with the attorney disciplinary process under rules promulgated by the Florida Supreme Court. Uh, whoop. Oh, yes, thank you for this. I saw that there are new documents in the federal 2 case. I will be getting to those tomorrow. Mondays, we just do Petty Monday because we got to start Mondays off with. Well, we got to start Mondays off with a laugh because, you know, I appreciate you sending that to me. Sorry, the little got too quiet. All right. Plaintiff's claims case was brought by plaintiff Leslie Federigo's during the course of disciplinary proceedings against her by the Florida Bar that were pending before the Florida Supreme Court. Those proceedings were subsequently dismissed following the plaintiff's permanent retirement as a member of the Florida Bar. In response to an order to show cause why this case should be not be dismissed for lack of subject matter jurisdiction for mootness, plaintiff has asserted that this case is not moot regardless of her retirement. Responses by the defendant on this issue are due by June 6th. This was filed June 1st of 2023. May just want to wait for both judges to do their work. I also got your message too. I just haven't had the time to read it. All right. In substance, the second amended complaint reflects plaintiff's disagreement with disciplinary proceedings. She alleges she believed she would not receive an impartiality under the procedures set forth in Chapter 3 of the rules regulating Florida Bar. In particular, she alleged Chapter 3 of those rules is unconstitutional due to the use of local bar investigative committees, which she contends are inconsistent with the recommendations of a 1992 report by the ABA, the damn McKay report. Plaintiff alleges that she has been harmed by the use of such committees. She also alleges that members of the Florida Bar have published discriminatory statements about her mental health in court pleadings and in open court. And that the Florida Bar has not taken measures to stop them. Plaintiff requests declaratory and/or injunctive relief in 4 counts, in which she asks for this court to deem Chapter 3 of the Rules of Discipline unconstitutional, and the Florida Supreme Court to follow the recommendations of the McKay report given by the ABA. You can't, the ABA, you can't force, oh my God, that's the thing, you can't force a state. You can't force a state to change how they discipline their lawyers. You just can't. Like, it's not a thing. And Annie thanks for the $20 super chat. Pacer fees suck. They do. That they do. And I appreciate the help with Pacer fees. It is very much appreciated. Oop. Oop. And I appreciate the other people who have messaged me. And there we go. Now I got it. And thank you, Lindy, for the $10 PayPal on Ko-fi. You are awesome, and I appreciate you very, very, very much. There we go. I love Ko-fi. Ko-fi allows me to talk to you guys so much more than super chats do, because I can respond directly to you. And Spawn Trooper, how are you? Uh, what? Oh, I think that was lost in translation. Uh, uh, she says we've pissed nothing away here, like time. All right. It just took time. Yeah, ABA is just a group of professionals, not a legislative body. So we're skipping over here. Mr. Rosenberg's proposed intervention. As described in his proposed complaint and intervention, Mr. Rosenberg was suspended by the Florida Supreme Court in 2015, disbarred in 2016, and permanently disbarred in 2017. Oh, look at all the case numbers. These proceedings began in connection with a finding by the Florida Circuit Court that Mr. Rosenberg's tactics in flouting its order that the very definition of bad faith conduct, and awarded the plaintiff sanctions. Oh, I'll have to look this up because this is summarizing disciplinary proceedings. Mr. Rosenberg's subsequent disbarment and permanent disbarment resulted from the Florida Supreme Court's determination that he was in contempt of its disciplinary orders. Oh, 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 oh. Mr. Rosenberg has filed multiple actions against state entities and officials in an effort to challenge the disciplinary proceedings, which have included actions he filed in federal court. These federal cases have included claims under the Sherman Antitrust Act and the U.S. Constitution. These cases were dismissed on grounds including sovereign immunity under the 11th Amendment. Mr. Rosenberg has also made numerous filings with the Florida Supreme Court, which led it to order an issue on January 13th, 2021, sanctioning Mr. Rosenberg for vexatious conduct and directing the clerk of the Florida Supreme Court is hereby instructed to reject or filing any future pleadings, petitions, motions, letters, documents, or other filings submitted by respondent unless such filings are signed solely by a member of the Florida bar in good standing. The Florida Supreme Court labeled him a vexatious litigant. Holy shit. And this is why we read this. Because, we would have never figured this shit out if it wasn't for Lips. Thank you, Lips. I'm really hoping this is what happens to you and all this stupid litigation you filed, but I mean, in the instant motion, Mr. Rosenberg asks for permission to intervene to assert claims under the Commerce Clause of the U.S. Constitution and the Sherman Antitrust Act, predicated on contentions that the Florida bar, as established by the Supreme Court of Florida, engaged in some wrongful conduct apart from enforcing the disciplinary orders. As Mr. Rosenberg states in his proposed complaint, the Florida bar's investigation of him for possible violations of rules regulating the Florida bar constituted an infringement of his right to participate in an area of trade free from interference by the state and free of monopolies. Did it so that was in his motion. That was also in Lips's motion when she was responding to the show cause order. She copied and pasted from him. She copied and pasted. She copied and pasted. And thank you for the and thank you to the let's gotta go back to my Ko-fi. Come on. And Ninja Puppy, thank you for the $10 Ko-fi. It is appreciated very, very much. I appreciate you so very much. She copied and pasted. She literally copied and pasted from somebody else's motion. And how did I not catch that until now? I mm. How did we not get oh, Jesus, she copied and pasted even back then. Maybe people are getting the copy and paste stuff from her. Oh my goodness. Mr. Rosenberg alleges that the resulting disciplinary orders continue to harm Rosenberg in that they harm his ability to work as a lawyer in Florida, Massachusetts, and New York. Oh, I just can't. I just can't. Sometimes you look at shit and you're like, I don't have to be a lawyer to know that that is absolutely and completely ridiculous. Completely ridiculous. Intervention is permitted where the moving party has claimed or has a claim or defense that shares with the main action in a common question of law or fact. But it is wholly discretionary with the court whether to allow intervention under Rule 24B. And even though there is a common question of law or fact, or the requirements of Rule 24B are otherwise satisfied, the court may refuse to allow intervention. Intervention is inappropriate because the case is due to be dismissed for lack of jurisdiction. I mean, yep. And we're not even going to read that because, like, yeah, we already just. I mean, intervention is inappropriate because there is no question of law or fact in common between the proposed complaint and intervention and the instant action. Mr. Rosenberg argues that his claims share a common question of law or fact with those of the plaintiff, but the only things that they appear to have in common are that both involve disputes over attorney disciplinary proceedings. Plaintiff claims purport to arise under the ADA and FCRA and due process clause of the Constitution, whereas Mr. Rosenberg's claims purport to arise under the Commerce Clause and Sherman Antitrust Act. The plaintiff alleges facts concerning mistreatment which are not analogous to what Mr. Rosenberg's allegations. Other than that, they both believe they were treated unfairly and harmed. This child of mine. Sweet, sweet child of mine. Yeah, we're gonna. Yeah, no more of that. Go get a wipe. No. Good thing they're just chalk markers. Let's put it that way. The plaintiff permanently retired as a member of the Florida Bar, whereas the Florida Supreme Court permanently disbarred Mr. Rosenberg. Based on a comparison of the issues, it's difficult to see how the claims are similar enough to justify allowing Mr. Rosenberg to intervene and litigate his claims with the plaintiff. No, she took some of the chalk markers from the LED light board that she has and gave herself a yeah. Oh my God, that would be fascinating in so many ways. The fact that both the plaintiff and Mr. Rosenberg were the subject of attorney disciplinary proceedings is not enough to warrant intervention. Although there is some factual overlap, there is also significant difference between the plaintiff's allegations of racial and ethnic harassment and the putative intervener's allegations of retaliation from participating in the investigation and that. Moreover, based on a comparison of the plaintiff's complaint and Mr. Rosenberg's proposed complaint in intervention, the underlying facts and law need to establish Mr. Rosenberg's claims and the plaintiff's claims are different. Oh, this brings a whole new mhm. But I have to go really quick because I want to make sure that her face is the only thing that has, and it's paint or it's chalk, so it's easily wiped up with a washcloth. However, she absolutely loves it. However, I got to go make sure that my walls don't have chalk marker on them. Be right back. All right, guys. It's okay. Mommy not mad at you. It's just here, wipe off your arms. All right, guys. Oh. Intervention is inappropriate because Miss Federigo's claims are also due to be dismissed on numerous other grounds. Yes. Baby Squid keeps her mama busy. These are forever memories for them to laugh about, but when she's an adult and they're laughing about the different stunts. Yes, I will be telling your boyfriends about this when you are older. By the way, let me see your forehead. Kiss. I love you. Sassy but no. Ooh. All right. All done. Oh, yeah. Go wipe off your pad. All right. Alrighty. The complaint is also due to be dismissed on a variety of other grounds raised in the motions to dismiss, including absolute immunity, standing, mootness, and intervention would not be appropriate on that basis as well. The same arguments for dismissal would apply to Mr. Rosenberg's complaint. While the Florida Bar focuses its opposition on the court's lack of jurisdiction over Mr. Rosenberg's claim and the lack of any common facts in law, the Florida Bar reserves the right to raise all appropriate defenses on a motion to dismiss Mr. Rosenberg's proposed complaint if intervention is allowed. Oh boy. For all these reasons, the court should deny Mr. Rosenberg's motion for permissive intervention. The motion makes it clear that this court does not have jurisdiction over Mr. Rosenberg's claims, nor do his claims share questions of fact and law with the instant case sufficient to warrant intervention. Finally, because plaintiff's complaints should be denied on grounds of jurisdiction and others, it would not be appropriate to permit intervention in this case. So basically, we have another lawyer, this one a disbarred lawyer, interjecting himself where he has no ground and no standing. Do you think this is where she learned how to do this, or was she that way before? Or is this just another reinforcement of bad behavior and thinking that her bad behavior is acceptable? I don't know. It is it's food for thought. because when we were reading through these things, I'm seeing behaviors now that I saw back then, and I thought that maybe it was just the situation and the YouTube and all of that that was kind of making people act a little out of, I can't say out of character, but a little wackadoodle. However, it sounds like she learned from other people how to act a wackadoodle a long time ago. Just saying. So, what did we learn? What did we learn? So, final thoughts. What did we learn tonight? Florida is full of attorneys who like to stick their nose where they don't belong. um, People were sticking their nose into situations where it didn't belong regarding lips a long time before lips got involved with the Jeremy Hill situation. It nuttier than a football bat. Yeah, she has had this pattern for a long time. Yeah, and we also got introduced to Mr. Rosenberg, who is a disbarred lawyer who, up until 4 months ago, was making headline news and is actually labeled a vexatious litigant by the Florida courts. Interesting. 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 Yes, don't be like them. This is a giant example of what not to do. And I don't have to be a lawyer you don't have to be a lawyer to look at something and go, that's not right, or that conduct is just weird, or that doesn't make any sense. And that's kind of what we do here. Huh. It's just, yeah, she seems to have no ethical integrity. Yeah, and what I am learning from this is, if you ever do need a lawyer, questions to ask and not to ask. And a track record to, when you're doing a Google search on an attorney, behaviors to look for. Like, do they have a YouTube channel? And what is the content of their YouTube channel? Is their YouTube channel like Larry Foreman or Florida lawyer, lawyer with the good hair, lawyer, or is their content like Lips and Michael Federico's? Pick your, this is where, when you need an attorney, do your research. Do your research, because if you don't do your research, your case might be in a world of hurt, not out of any fault of your own, but because you had a shitty attorney. In the case that is going on in Athens, I'm thinking that the defendant is innocent. However, his attorney is just so damn insufferable that I'm afraid that he might be convicted on some shady science because his attorney is an idiot. So it's pick your attorneys wisely. Do your research. And don't get caught up in a situation that you could regret. Anyway, I'm going to see, Spawn, are you going live today? What I don't get is Lips with a Florida bar member. She agreed to the rules, didn't follow them, and now claims boohoo, not fair. In my opinion, if she never joined the bar, maybe she would have a point. Yeah, And Ong Hero, so good to see you. Thanks for the 5 gifted Squid Pro Quo memberships. Turn in the chat green. We have had a membership flood today. It's like 20 or 25 or something like that. Yes, do due diligence. It's, it's a hope you are doing well. Dan Newland, I worked with him as a homicide investigator prior to him passing the bar. This was Erwin Rosenberg. Ugh. Alrighty. Y'all have a great day. I'm going to see if we can send you somewhere on YouTube, because you know how I love not sending you off on your to your own devices. Let's see. And thank you to the 2 people who hit the dislike button. Yes, about to hit the go button. Did you set it up so that I could shush phrasing? There was a pause there to prevent things like you comments like yours. But thank you for the $2 super chat, Unknown Hero. It is always appreciated. And I'm glad that we could have fun on this this Monday together and we could laugh. For those who want the rest of the documents in this case, I do have a Loose Lips Sink Ships playlist just for her, because this is what the Hales adjacent. It does not directly address Jeremy Hales. However, the things that I am learning from it, and the reason why I still use What the Hales in the thumbnail, is because I am slowly learning. Every document I read is something that I'm slowly learning there might be things in these documents that Jeremy might be able to use in his case against Lips. So that's why Jeremy's, and I know that might be a criticism to some people that I'm using Jeremy's name. Well, I'm using it because most people don't know who Lips is by herself. And secondly, I'm finding things in here that there may be a pattern. And patterns, yeah, they are unbelievably great content. And that's the thing. I'm not going to sue anybody for defamation because it takes too much time, effort, and when they don't actually have anything I can use. So I'm going to use them for entertainment value. And because I get some serious entertainment out of making fun of Lips. And the thing is I never would have, because I did 2 streams on her in 2025, May and June, or April and May, something like that. And then I never talked about her again because she wasn't relevant until the text messages and the smexy time stuff, allegations against Jeremy, and the FBI report against Radis. So I talked about those things because they were news. And then she decided to call me a felon and my petty side. So we are going over and redirecting to Spawn Trooper because he is live right now. So y'all have a great day. I will see you over there for a couple of minutes. And I will see you tomorrow to go through the documents in Federal 2. So I will going to watch replay. I got home from buying food for my lockup. And FYI, Lori is not being locked up. She's having surgery. So everybody wish her well. She will be down for the count for a little bit. But she will come back better than ever. Better than ever. And we will see you guys tomorrow. Bye.